Hi, everybody. This is Sandy Andre from Miller Johnson's Labor and Employment Group. Don't worry, I'm not here to talk to you about COVID-19. Instead, today, Miller Johnson's Education Group has asked me to join you for the next 5-minute video update. On July 19th, the Michigan Court of Claims determined that the Michigan legislature violated the Michigan Constitution when it adopted and then amended 2 ballot petition initiatives in 2018. Importantly, that ruling voided 2 laws, the current Michigan minimum wage and the current Michigan Paid Medical Leave Act. And if this decision remains in effect, this will have a significant impact for all Michigan employers, including school employers. Now, because you are educators, I know you won't mind a brief history lesson. In 2018, 2 advocacy groups circulated a petition to raise the state's minimum wage and to enact a paid sick time law. Michigan's legislature had a couple of options. One, they could adopt the measure. Second, they could reject it and let the ballot initiatives go forward to the November 2018 ballot, or propose an initiative of their own, and both the proposal and the initial ballot initiative would both appear on the November 2018 ballot, and voters would decide. September of 2018, the Michigan legislature adopted both of those proposed laws, and both of them, the update to the Michigan minimum wage and the Paid Sick Act, were set to take effect in March of 2019. However, after the election in 2018, the legislature actually amended both of those laws, and it was the amended laws that actually took effect for the first time in March of 2019. And those 2 laws are what we know today as Michigan's minimum wage and Michigan's Paid Medical Leave Act. So that's how we got here. But what are the differences? Probably for most of our school employers listening, the potential changes to Michigan's minimum wage aren't nearly as significant for you. But the changes and the differences between the Earned Sick Time Act and Michigan's Paid Medical Leave Act are significant. And these differences include things like the following: where Michigan Paid Medical Leave applies only to employers with 50 or more employees, the Earned Sick Time Act applies to all Michigan employers with at least 1 employee. The Paid Medical Leave Act has a number of exemptions. We know this. For example, salaried exempt employees are not covered under Michigan's Paid Medical Leave, but that's not true under the Earned Sick Time Act. All employees, there's no minimum number of hours threshold that an individual has to work to be eligible for some form of earned sick time. All employees, all Michigan employers, very, very few exceptions. Certainly, in addition, it expands the definition of family member. Under Michigan's Paid Medical Leave, we're used to an individual being able to take time off for a family member, to care for a family member related to that family member's injury, illness, diagnosis, preventative care. Under the Earned Sick Time Act, that definition of family member includes individuals who are domestic partners or other individuals related by blood or affinity whose close association with the employee is equivalent to what we would think of as a family member. Importantly, the Earned Sick Time Act would require employers to provide paid time only through an accrual method. For those who are compliant with Michigan's Paid Medical Leave, you know you have 2 choices, either an accrual-based method or what I kind of call a lump sum method. Under the Earned Sick Time Act, only an accrual method is available, and employers must provide at least 1 hour of paid time for every 30 hours work, as opposed to 1 hour of paid time for every 35 hours worked under Michigan's Paid Medical Leave Act. Additionally, the Earned Sick Time Act would require employers to provide, to allow employees to roll over unused time and use up to 72 hours of earned sick time, paid earned sick time every year. So now, since that July 19th decision, the state of Michigan has filed an appeal, and the Michigan Court of Claims has granted a stay. This means that Michigan employers have until February of 2023 before they're required to implement the Michigan minimum wage requirements and the earned sick time requirements. But it's really important to understand that this continues to be a developing story and many questions remain. As I mentioned, the state of Michigan has filed an appeal. Additionally, there could be new legislation. For example, we know there's a separate ballot initiative supporting a different minimum wage that has reportedly gathered enough signatures and is set to appear on the 2024 ballot. For now, you've got until February 2023 before the state of Michigan plans to enforce the Earned Sick Time Act parameters. So between now and then, dust up your policies and call your favorite education group attorneys and ask for some guidance. Until next time, have a great day.